Go out.
It's not too deep as the ocean goes deep.
I'm talking about my son's life. And I'm talking about the lives of other black kids. Do what the hell you want to do. Go ahead. But you can't silence me. But you are not going to silence me.
We know that the government is running.
Prove it guilty! Due process!
Due process for due process again! Due process for
wellness check!
Hey everybody, I'm your host Texas Black Diamond, and thank you for tuning in to Texas Black Diamond ENT.
Go out. Welcome everybody. Hi, Miss Queen. How you doing, everybody in the room? I'm gonna try to get through this like really quick. Y'all know how I am. Welcome to the channel. As I said in my intro, I have three different motions that I wanted to present, and I'm just gonna let it read through, and I'm gonna write my notes down and talk about it. I know other people probably read the motions on their channel, but I am gonna be listening to it at the same time that you guys are listening to it, so I can give my opinion on it as well. We have um, the government. I think it's two motions that they did. I downloaded three, so I'm not sure what it is because I have not had a chance to read through it. So we're going to listen to it together. Please leave your comments down below. Let me know if you guys hear me. I'm going to check and see. Please leave your comments down. Okay, you guys can hear me, so that's good. You guys can hear me. So we're just gonna go ahead and get started because I think it's only 12 with Jennifer Bunjean, and then I think it's 33 pages with the U.S. And on the other one, I'm really not sure. Just let me check real quick so I can see how many pages on here. Okay, this is Jennifer's. It's 45 pages on one, and oh my God, 109 pages on the other. Oh my God, honey, we're gonna have to skip through this. They down the details to Faith. They're talking about Aaliyah, Kate, just everybody. They just got them all in alphabetical order. Talking about the RICO. We're gonna skip these tables and verses. They have so many verses in here, you guys. So many. So I think that will be the last one that we do. Is 732. So we're gonna go ahead and get started. We're gonna get started with Bonjean's first, because that's what I have up on the screen. So just nope. Put your notes down, y'all, and let's see what these people talking about. Let me see if y'all can hear me. 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 Okay. I'm gonna have to take off my Bluetooth. You guys, let me disconnect it real quick because you can't hear what's going on with the motion. Okay.
Of uncharged bad act evidence that served no legitimate evidentiary purpose. With the court's blessing, the government subjected the jury to massive heightened conduct for the primary purpose of depicting defendant as contemptible, sexual deviant. The government defended the introduction of the evidence as relevant to the means and methods of the enterprise with nary a word of Rule 403 considerations. For reasons argued in defendant's Rule 29 motion, the government's evidence of an enterprise was insufficient as a matter of law. This case was not about an enterprise, it was about the conduct of one man who the government sought to punish for his alleged history of mistreating women. As such, the mountain of bad act evidence offered in this prosecution was nothing more than inadmissible propensity evidence. Because defendant was forced to defend against dozens of uncharged claims of abusive and sexual misbehavior, much of it lawful albeit unpalatable for some, defendant was stripped of the presumption of innocence and denied a fair trial. But that is not all. Defendant was denied effective assistance of counsel when his attorneys failed to file adequate pre-trial objections to the introduction of the mass of overly prejudicial propensity evidence and routinely failed to lodge timely objections to some, although not all, of the damning bad act evidence. In sum, defendant's trial was little more than a reenactment of the one-sided docuseries Surviving R. Kelly, which several of the jurors had viewed before stepping into the courtroom. It is a wonder that the government did not simply offer the docuseries into evidence. With this case 1-2 backdrop, defendant was powerless to defend against the charged offenses for which there were viable, even winning defenses. Defendant was denied his constitutional guarantee of a fair trial where the jury heard excessive, minimally probative evidence of contemptible conduct that was introduced solely to inflame the passions of the jury and punish the defendant for decades of unchecked bad behavior. Relevant facts in the 2 months preceding the start of defendant's trial. His defense team was focused on fighting one another and preoccupied with litigating a Curcio hearing on account of his attorney's disabling conflict of interest. Not surprisingly, defendant's trial team wasted valuable time and resources focused on this side circus rather than preparing a strategy for defending the case. At the defendant's request, this court granted an extension for the filing of motions in limine until July 23, 2021. DKT Number 131. On July 23, 2021, the government filed a whopping 55-page Motion 1 seeking to admit a heap of prior bad act evidence. DKT Number 133. Defense counsel filed no motions in limine. Incredibly, defense counsel failed to preclude any uncharged bad act evidence that was produced as part of the government's 3,500 materials. On July 30th, 2021, defense counsel filed a written objection to the government's motion in limine regarding the introduction of prior bad act evidence, largely on timeliness grounds.
Okay, I'm gonna move over to
DKT.
the
Number
let me pause.
145. The response contained a general objection to the evidence is untimely with no meaningful.
I want to move over. Hi, hello everyone. I want to move over to the government. So basically, what I'm seeing here, and then we can go back because she only have 12 pages, and I just want to see what the government has to say. But also, Nicole, not Nicole, but Bunjean, she's saying 2 months. I know Greenberg is her friend, but Greenberg needs to be called out too. Greenberg was the lead attorney. Okay, 2 years of BS was happening during Robert's, going through his trial hearings and preparing for the trial. And you would think that they would have been better prepared for his trial, and they wasn't. And but they're putting everything on one person. And I still say right today, I think that Tom, was better than them all. They can say he has some kind of speech problem. They can say he have a some kind of mental problem and things like that. But he always spoke up. He wasn't afraid to speak up. But they always tried to shut him down. And you guys remember the judge tried to do that. But she needs to start from A to Z, because Greenberg, as a lead attorney, he always trying to blame Thomas for filing. But what did you do, Greenberg? What did you file? What did you have a conference with your team as well as your client? Did you guys sit down and strategize? And did you guys talk? Did you have these other counselors to go over their motions that they were going to file, to read them out loud, and everybody go over everything and say, okay, well, that's good, but we need to add this in there. We need to get this filed within a week. Let's not wait until the deadline. Let's get it done 2 weeks. Matter of fact, let's get it done right now. Let's stay overnight. Make sure we get everything right, and let's get these motions filed. So I think Jennifer Bunjean, when I read hers, it was more about 2 months. So Canic came in 2 months. So basically, you can't put the burden on Canic, a last minute counselor. Yeah, you can put the burden on all the other ones, but you need to call out Greenberg. You need to call out Greenberg and the BS he had going on. You need to call out Doug Anton with his circus of YouTube friends. Call these people out. Don't just try to call out Kenny, because Kenny just, when you say 2 months, that's when Kenny came on. You had Nicole and all these other ones. So Greenberg was the ring leader. Greenberg was Stripe, from the Gremlin. He was Stripe. He was the ring leader. He was the head leader. And as an attorney, a lead attorney in a big case like this man should have, had his stuff together and made sure his team, because when you have these people on your team, it's your team. So you're gonna make sure everybody is doing what they're supposed to do. And you're gonna do a follow-up. And right today you have Greenberg on Twitter blaming Thomas. Like, why are you blaming Thomas? Thomas not the media whore. Thomas doesn't like the cameras. He don't like to be in the camera. He don't even like speaking to anyone. He just want to do what he got to do and go on about his business. He's not trying to be in front of a camera. He's not trying to be on a blogger's page. He's not trying to talk to the journalists or anything like that. So he's not a media whore. So I don't know why Greenberg has this bone to pick with him when he should be calling out Nicole ass. Because she went in and manipulated Robert, from what I hear, But why you pick on the weakest link? And as an attorney, I'm like, damn, you're not taking responsibility for what you were responsible for. You're not taking accountability for your actions and what you didn't do, but you want to point fingers to on everybody else. And I think Jennifer needs to call out from the beginning to the end. She needs to call out Greenberg. And then we did some talking behind the scenes, and I think when I was reading just a little bit because I had to leave with the government when they were speaking on the situation about Robert, and he had the ability to, say nay or yay. But you guys remember, and I will never forget it because I was pissed off. And someone was like, "Well, that was good. She was just trying to keep him quiet so he won't, mess up himself." But Robert tried to speak. If y'all can remember, like Robert, he tried to speak. Robert tried to speak. Robert tried to tell, this lady what he felt and why he felt the way he felt about his counselors and why he no longer wanted those counselors. So I felt like in my heart of heart, because you guys know I came on here and I was PO and I was going off and cursing and crying and everything. And I said you know, she did not give him the opportunity to speak. And everybody like, I know y'all want to hear him speak and y'all just want, but she did her job. Ann did not do her job. Judge Sidebar did not do her job because she asked him, and did everybody have something to say? Mr. Kelly, do you have anything to say? And that's, y'all remember this. I will never forget it. And he was like, "Yes, Your Honor, thank you for giving me the opportunity to speak." And she cut him down cold. Boom, cut him down. And she knew what she was doing when she was like, "Okay, whatever. I'm gonna assign this counselor to you. You need to know what you're doing." And so when they went back to the pre-trial, y'all remember when Judge Ann was like, "Okay, are you sure? Because we're not going to go back and have a mistrial. We're not going to do a retrial." And see, it was like she knew, as Judge Sidebar knew the situation, and as a judge with Nicole, she knowing what she knew about Nicole, she knew exactly what she was doing. She's like, "Yeah, this is a messed up situation. His counselors, everybody arguing, and y'all put this stuff in writing. Stop, don't do this on here." Y'all remember that? She knew it was a ram shack with these people. And then she was like, "Okay, well, I'm not gonna uh, grant any more extensions on the trial. We're gonna have trial as is, as the date that I have set." Y'all remember that? And I said, this woman is full of balls. She got balls. And I'm gonna pull up the this dude. Let me see if I can pull him. Matter of fact, I think I have it here. I want you guys to see this. The lead district attorney, and he had to go in and he wanted to help these ladies, made sure that he put his DNA on it. So if on this picture here, let me upload it real quick, because I know y'all remember, because I don't forget nothing. So you guys, do y'all see um let me see if I can move this thing over. I don't know why this thing. We pay money for this thing. We should be able to move our pictures the way we want to move them. But anywho, you see the black guy there. He was appointed by Joe Biden, you guys, as the lead U.S. District Attorney in New York. And Lord, let me pull his name up. Let me see if I can remember his name before my battery died. Because I was doing my research on him. I'm like, Okay. Okay. All right, sir. Let's see if I can pull it back up. I guess I was looking on the other one. Okay, New York District Attorney. Y'all gotta excuse me because I thought I had everything a ducks in a row, but I don't. Blame it on me. But he's a lead attorney, U.S. District Attorney, a black guy. Um, and so I was kind of shocked. I'm like, damn. So I was shocked to see. But anywho, let me go ahead and move on over to these damn other people and let's hear
Number
what they gotta say.
104.
Let me stop Jennifer's and let's move on to these people here. Let's see. How many pages? Okay, 145 pages on this one. This is the U.S. government. Yeah, yeah. Okay. So y'all do y'all research on old dude.
Free and Peace.
Brian Peace. Okay, that's his name. So we're gonna do our research on him in a little bit.
United States District Court, Eastern District of New York X. United States of America. Against Robert Sylvester Kelly, is also known as Art Kelly. Defendant X. 19 CR 286 S3 AMD. The government's response to defendant's motion for a new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure. Free and Peace, United States Attorney, Eastern District of New York, 271 Cadman Plaza, East Brooklyn, New York, 11201. Elizabeth A. Geddes, Nadia Shahada Maria Cruz Melendez, Assistant U.S. Attorneys of Counsel. Case 119
Which one reading? I'm trying to see
CR0286
which one
MD
reading.
Document 277 filed March 21st, 22, page 1 of 45, page ID number 10980. I. Table of Contents. Introduction.
Let me
1.
skip through that, man.
Applicable
It's just a
law.
lot of
1. 2.
stuff.
The defendant was not denied effective assistance of counsel during voir dire. 1B Legal Standard.
Let me skip through that.
1.
It's a lot.
Juror number 3, formerly prospective juror number 25. 34. Table of Authorities. 2013.
It's a lot.
1998. For Figueroa versus Ercole,
Ooh.
2013 WL 3,600,000. 6. 7 Murphy versus Florida, 421 U. 2D
Let me try to
113
skip, y'all. It's a
117
lot.
SD 31 33 34 Case 119 CR002H6 IV. United States versus
Ooh,
2003.
Lord.
32 United States versus Perez. Page 1.
Okay.
Introduction. The defendant seeks a
Whew.
new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure, Rule 33, as a result of his conviction on September 27, 2021. Of 9 counts charging racketeering and multiple violations of the Mann Act. In his motion and supporting memorandum, Mem. The defendant argues that he 1. was denied effective assistance of counsel because his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, and 2. was denied conflict-free counsel under the Sixth Amendment because one of his attorneys simultaneously represented the victim who testified at trial under the pseudonym Jane. See generally, Mem. ECFEKT. Entry number 270. For the reasons set forth below, the court should deny the motion in its entirety. I. Applicable law. Rule 33 provides that the court may grant a defendant's motion for a new trial if the interest of justice so requires. Fed. Art Grimm. Pages 33.
Where I'm at?
However, motions for a new trial are
wrong one.
disfavored in this circuit, and the standard for granting such a motion is strict. Quote. United States versus Gambino, 59.3D 353 364 2 DCIR. 1995. Accordingly, courts must exercise their Rule 33 authority sparingly and only in the most extraordinary circumstances. United States versus Sanchez 969 F2D 1409, 1414 2 DCI 1992. 2. The defendant was not denied effective assistance of counsel during voir dire. The defendant asserts that he is entitled to a new trial where his trial team conducted no meaningful voir dire and acquiesced to the seating of jurors who were unqualified to serve on this jury. Mem. At 1. This claim lacks all merit. A. Relevant background in order to facilitate jury selection in this case. 2. Jurors completed a comprehensive 28-page questionnaire comprised of 108 questions. CECFBKT. Entry number 115. The court then invited the parties to submit challenges to any prospective jurors based on their questionnaire responses. The parties thereafter submitted a joint list of 251 prospective jurors they agreed should be stricken for cause. ECFBKT. Entry Nos. 152-157. In addition to the agreed upon for cause challenges, the government submitted a list of 34 additional prospective jurors it challenged for cause for various reasons. And the defendant submitted a list of 145 additional prospective jurors he challenged for cause for various reasons. ID. The court then directed the remaining prospective jurors who are not challenged for cause by either party based on their questionnaires to appear for an in-person voir dire. Over the course of 2 days, the court conducted in-person voir dire in 2 phases. During the first phase, the court addressed the prospective jurors in a group setting, advising them of multiple principles of law, including the burden of proof, the defendant's presumption of innocence, and the need to follow the court's instructions. VDTR 17-18, 21, 189, 197-98, 201.1. During the second phase, the court spoke with the remaining prospective jurors individually, outside the presence of the making further inquiries of each prospective juror, including posing additional follow-up questions submitted by the parties in writing and orally during voir dire. During in-person voir dire, the court excluded approximately 34 prospective jurors for cause for various reasons, including scheduling conflicts, English comprehension issues, financial hardship, and concerns about the prospective jurors' impartiality. VDTR 22-23, 26, 50-51, 65, 81. One after voir dire was. 1 references to the transcript of jury voir dire in this case are cited at BDTR__. 3. Complete. The parties exercised their peremptory challenges from the pool of qualified prospective jurors, and the court subsequently seated and swore 12 jurors and 5 alternate jurors to hear the case. Point 2 VDTR 434-457. 459. Following the close of evidence and the court's final instructions, the 12 jurors deliberated, ultimately finding the defendant guilty on all 9 counts in the 3rd superseding indictment. With respect to count 1, which charged the defendant with racketeering, the jury found that all racketeering acts, except racketeering acts 3 and 4, had been proven by the government. None of the alternate jurors was called on to deliberate. B. Legal standard. A defendant who attacks his conviction based on claims of ineffective assistance of counsel must 1. Show that counsel's performance fell below an objective standard of reasonableness under prevailing professional norms, and 2. Affirmatively prove prejudice, i.e., demonstrate that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Strickland v. Washington, 466 U.S. 668, 688, 693. Accord Hernandez v. United States 202 F3D 486, 488 2 DCIR 2000. Under the Strickland standard, a petitioner must establish both 1. That counsel made errors so serious that defendant was deprived of reasonably competent representation, and 2. That counsel's deficient performance.
Okay, let me pause right there. I was doing my best not to step end, but oh my gosh. Okay. Y'all remember Nicole, what she said when she was doing when she was doing the opening arguments. And she kept making all these freaking mistakes, and Judge Sidebar would get pissed off at her. And so Kenny had to take over because she told the jurors that they must find him guilty. Who remember that? I said by that alone was kind of messed up. There was just a lot of mess. Everything was just out of order, all over the place. Excuse me. Y'all know my logo blocking. I be paying for this stuff on my own. I don't get the privilege of free documents. People don't send this stuff to me, so I'm not gonna be sharing mines like that. Okay. I used to do stuff like that, but I waste my money. But if y'all remember, y'all remember that when Nicole did all of the mess up, and then Candy just had to step in, was like, damn, and Robert probably like, please take over, because this woman here, and she was like, she was nervous, and because I went back and I read Nicole's opening arguments on the transcripts. I'm like, what the hell you had going on, And so I'm like, damn, you was here from the beginning, and it seemed like you alone as the woman of the group, you should have had stuff written down. You should have had your notes. You should have practiced on the opening argument. You want to take over this case, you should have done better. So to me, I just felt like she was just like a rat in the hole trying to get the cheese and then leave him hanging. And I felt like as his counselor, I wouldn't hire her if she was the only attorney available to me, because at the end, you did what you had to do, seemed like to me, but you didn't even show up for the verdict. You didn't show up for the verdict. You claim all of a sudden the day of deliberation, you got COVID. And I call it BS. That's BS to me. Where am I at? Okay.
A petitioner must establish both 1. That counsel made errors so serious that defendant was deprived of reasonably competent representation, and 2. That counsel's deficient performance prejudiced the defense. Both prongs must be satisfied to succeed on an ineffective assistance claim, and the court need not address both components if a defendant fails to establish either one, as a failure on either showing is dispositive. Strickland, 466 U.S. at 687, 697, 700. 2. Prior to swearing in the jury, one of the alternate jurors was excused for reasons related to financial hardship. T. 144, 358-59, 4. Case 4. 1. Deficient performance. With respect to the first prong, a defendant must identify the acts or omissions of counsel that are alleged not to have been the result of reasonable professional judgment. The C. Court must then determine whether, in light of all the circumstances, the identified acts or omissions were outside the wide range of professionally competent assistance. Strickland, 466 U.S. at 690. Judicial scrutiny of counsel's performance must be highly deferential at 689, and strategic choices made after thorough investigation of law and facts relevant to plausible options are virtually unchallengeable. ID at 690. See also Henry v. Poole, 409 F.3d. 63 2D CIR 2005. Actions or omissions by counsel that might be considered sound trial strategy do not constitute ineffective assistance. Internal quotations omitted. Moreover, evaluating counsel's performance must not serve as an opportunity to act as a Monday morning quarterback. United States versus Scali, 2018 WL 3,536,082 at asterisk 4 SDNY July 23, 2018, citing Strickland, 466 U.S. at 689, Ease versus Senkowski, 321 F.3D, 110, 132 to DCIR. 2003, a court must not use perfect hindsight to criticize unsuccessful. Strategies, Greiner versus Wells, 417 F.3D, 305, 319 to DCIR. 2005, 417 F.3D at 319, finding that the performance inquiry examines the reasonableness of counsel's actions under all circumstances, keeping in mind that a fair assessment of attorney performance requires that every effort be made to eliminate the distorting effects of hindsight. Quoting Rompilla versus Beard, 545 U.S. 374, 389, 2005.
What a juicy
Rather,
stuff
a court must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance. That is, the defendant must overcome the presumption that under the circumstances, the challenge action might be considered sound strategy. Strickland, 466 U.S. at 689, quoting Michelle versus Louisiana, 350 U.S. 91, 101, 1955. The Second Circuit has defined a strategic decision as a conscious, reasonably informed decision made by an attorney within Case 119 CR002H6 MD Document 277 filed March 21, 22, page 9 of 45, page ID number 10985. I to benefiting his client. Grenier versus Wells, 417 F3D 305, 325 to DCIR.
Wait a minute, y'all. It's too much siding in this. I don't know. I don't know if I have patience, y'all, to go through all this. But let me know if y'all want to continue to hear all this stuff, the 35 pages, because I'm just chill. I sit here with y'all, listen to it. If this is what y'all want, I just don't understand. It's just all these verses and stuff. It just and the black man, I'm so disappointed in you, Mr. Peace, the district attorney. He just, oh Lord, let me see. I gotta find him. Y'all inquiring minds. Hey baby, how you doing, Miss Rita, and everybody that stepped in the chat. Let me see if I can find this guy. New York. I have a short. These people, I'm getting bored. We have this short span of listening. Did y'all hear about the Kool-Aid? This week, attorney. New York. Okay. New York. Eastern District. It's supposed to be BR. And I was just searching him. He was appointed with by Joe Biden. Somebody else supposed to been coming on here taking over you guys, because I am like really in slow mode. You said what Kool-Aid? Ooh, he said he got with. I told y'all. Mr. Kool-Aid said when we first came on, it's like y'all did what he needed us to do, spread his name, spread the word, and like tell everybody, just so they can come over there and check him out, stuff like that. And he was talking about Kool-Aid and the man in the prison and the Muslims and how you trick somebody. And he ain't trying to bring Joy out the rabbit hole. What can she offer him? And stuff like that. But he was saying a few things about the situation with Robert, and and Joy, and and he's saying that he feel like Robert has to take care of Joy because Joy might end up doing this and doing that and stuff like that. I'm like, okay, if he decide, I can't afford to be trying to upkeep her and she needs to, go out and do things for herself, then she can't get mad. But if she go out and she say something about um him, I would feel like there's revenge and retaliation, and you'll say any and everything to try to, you know, seek revenge. But if y'all want to continue with this motion, y'all please put a one in here, and I'll let y'all continue to hear it, because I was gonna do a panel so other people can come on and talk about it. But we can continue.
To benefiting his client. Grenier versus Wells, 417 F.3D 305 325 2 DCIR. 2005 internal citation and quotation marks omitted. When examining an ineffective assistance claim in the context of jury selection, consistent with Strickland, an attorney's actions in conducting voir dire are also afforded deference. Ciaprazzi versus Senkowski, 151 FAP 62, 63 to 64, 2 DCIR. 2005 holding that trial counsel's decision not to seek an alternate juror is paradigmatically strategic. Indeed, courts are loath to second-guess the decisions of counsel during jury selection. Tech v. Superintendent 2009 WL 2,496,607 at asterisk 8 WDNY August .13 2009 citing Dolio versus Reynolds 2002 WL 920. Strategies as to the exercise of peremptories are matters of counsel's intuition and do not rise to the level of constitutional violation. It is not the role of the court to second-guess counsel's reasonable strategic decisions at jury selection, especially considering that counsel is strongly presumed to have rendered adequate assistance and made all significant decisions in the exercise of reasonable professional judgment. Dolio 2002 WL 922,206 at asterisk 4 to 5 quoting Strickland 466 U.S. at 688. See also Cordova versus Johnson 993 F up 473 528 WD text. 1998 an attorney's actions during voir dire are considered to be a matter of trial strategy and cannot form the basis for an ineffective assistance claim unless counsel's tactical decisions are so well chosen that they permeate the entire trial with obvious unfairness.
Hell, it was
Additionally,
unfair.
if a defendant fails to demonstrate that he requested that his attorney exercise a peremptory challenge for particular jurors, the petitioner is deemed to have acquiesced to the attorney's decision not to do so. See, e.g., Kirkendall versus Matsuka, 2008 WL 3,851,820 at asterisk 27 WDNY August 15, 2008. Petitioner has failed to demonstrate he requested. As such, petitioner is deemed to have acquiesced in case 119C6. Trial counsel's decision not to do so, citing United States ex rel. Reed versus Richmond 295 F2 D83 89 to 92 DCIR 1961.
Let me ask y'all a question on here. Listening to the DA when they were speaking on his counselors. What was the counselors gonna do when every time they tried to do stuff that the judge sidebar, judge overrule, judge sustain? Every time you look around, it's like she's always coming at the counselors, the defense team, and trying to discipline them, just like she shut down Thomas. And she couldn't stand Nicole, and then she Judge Sidebar checked Canick. So he and Canick I think he was cross-examining, I think it was Azriel or one of the females, and he asked her, he said, are you going to continue to be doing this? Because if you are, I see no reason for us to even try to even um get up here and try to, you know, talk to these people. And I remember that. Like he confronted her on that. So everything, even from the pre-trial, Judge Cyborg will always strike everything that they try to say or try to, you know, file and stuff like that. So what was for them to do? Just like the with the just like with the parents, they wanted to challenge the parents. They wanted to speak to the parents, and everything that the DA put in motion, Judge Cybar agreed with them. And we talked about this, and we was like, why is she? It's like she's not giving the defense team anything. It's like everything, like, well, we're gonna have the text messages up here, but we're gonna black that out. We're only gonna have Azriel text messages and not the mother that's trying to set up this guy. And we're not gonna allow you guys to bring up the parents. And so, and that's BS to me. All right, TBD. What was he supposed to do? Beat them up? Yeah, y'all everybody witness Judge. That's why I call her Judge Sidebar. Like every time, like when Kennick was trying to get in their asses, Judge Sidebar will stop it, and she will call him to sidebar. We need a sidebar meeting. I'm like, every time this man get into these women's asses, and then who was that? She confronted him about, one of the witnesses started crying, and she told him, "Don't do that anymore." Like, why would you say that in front of the jurors? And I was like, I'm like, this woman is she working with them? She might as well get down and sit at the table with the DA, because it's like she's working for the DA, and when the DA make a mistake, she corrects what the DA uh, mistakes. She corrects it. And these three women made lemons out of lemonade. They made lemons out of lemonade, you guys. So let me get on with all this shenanigans. I'm
1961, holding the defendant's acquiescence if trial counsel's strategic decision amounted to forfeiture of defendant's right to assert constitutional infirmities.
Yeah, you
2.
did. Hell.
Prejudice with respect to the second prong, an error by counsel, even if professionally unreasonable, does not warrant setting aside the judgment of a criminal proceeding if the error had no effect on the judgment. Lindsat versus Keene, 239 F.3d 191, 204 to DCIR. 2001, quoting Strickland, 466 U.S. at 691. Thus, to establish prejudice under Strickland, the defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. Strickland, 466 U.S. at 694. A court must review the prejudicial effect of counsel's errors in the aggregate. See Lindsat 239 F.3d at 199. Moreover, like the determination of trial counsel's performance under the first prong of Strickland, the determination of prejudice may be made with the benefit of hindsight. Street versus Greiner, 491 F.3d 84, 91 to DCIR. 2007, quoting Mayo versus Henderson, 13 F.3d 528, 534 to DCIR. 1994. To establish prejudice stemming from trial counsel's failure to challenge a prospective juror for cause during voir dire, a defendant must establish actual bias. See Castro v. United States 993 F's up. 2D332 EDNY 2014. However, to maintain a claim of ineffective assistance of counsel based on the failure to object to a biased juror, the petitioner must show that the juror was actually biased against him. Accord Mitchell versus Herbert,
Well, hell,
2008 WL
let
340
me
at
pause this.
asterisk 7 April 19, 2001. Based on the lack
Hold
of
up.
the petitioner has not case
Let me get to
7
the right page.
demonstrated.
Let me get to the right page. Y'all, let me tell you something. Just listening to this medicine for anxiety and stuff that people got me on is not working. They up my dose, and I swear this listen to these three blind mices. I'm just they got me. Damn it! I'm trying not to curse. What the hell? Y'all, they know what them Jurors talking about. They didn't have nothing against them and bias and all that. But you're a damn lie. Somebody lying. According to the information that we couldn't see, Jennifer Bonjean pulled it up about these damn jurors. One of them was in love with Gloria Allies. So you know she was part of the Me Too movement. Half of them watched the Surviving Lives. And these people had their minds made up. They went in there with their minds already made up. I mean, who goes like how long was this case and then the trial? And you go in there for 9 hours just sitting there where we're gonna sit in here 9 hours, eat some cookies and have a few drinks and here we already know what we're gonna say when we go in there. And the only thing this trial was about a hearsay and this man dingaling. Okay? Hearsay and this man dingaling. And everybody is at an uproar like he done did something so bad with some consensual people that want to have sex with a celebrity. Okay? Tina Turner says, some like it rough, some might like it rough. Some might want to hang on chandeliers, some might want to swing on the ceiling fan. Some might want to turn on the dryer and the wash machine and do something. But they tried, only thing they talked about was this man's bedroom life as a player. A single man doing him, and he letting everybody know I'm doing me. And if they chose to hang around, that was their freaking business because they was lazy, money hungry, running after somebody else's fame, using people. Because I don't think these people did was use him. And they trying to act like these women had something to give him and he was using them. A nappy dugout. He earned a nappy dugout in a two, probably a what, 10 minutes to 2 hours of feeling. And if it felt good, can it be duplicated again? 9 times out of 10, no. Well, I just find this BS, y'all. I'm trying to get through this, y'all. Ooh.
Demonstrated that he was prejudiced by his counsel's failure to strike these jurors and has therefore failed to establish ineffective assistance of counsel. Actual bias is bias. In fact, the existence of a state.
Wait a minute, cause see, I'm sorry, y'all, cause see, my memory been coming back. Didn't Kenneth on several occasions try to shut down some of these jurors? What did Judge Sidebar say? He can say it. He can object. I don't want this one. What she do? They all right. They can stay. So I don't know what three blind mice him too movement is trying to do. And the lead attorney, he is. I'm gonna have to find it. Thank you, Nicole. Because I'm as I'm listening, like stuff pops up, and I remember. I'm like, damn, Judge, and can you please give him something? And you can look at every. Go back and look at the pre-trial. Go back and read the transcripts. See all the denials that this woman has done on with his counselors and Robert. See how many times she denied the U.S. government. Okay, and y'all remember me saying, I'm like, damn, Judge, and you are you the judge? What the hell are you? Why are you trying to help them? She wasn't allowing them to do anything, and and Thomas, I forgot what he said. I'm gonna have to go back and find that transcript. But it was something about the violation. He was being violated on something, and she put the wrath on Thomas, and she shut Thomas down, wouldn't allow him to finish saying what he had to say. And every time when Nicole says something, so that's I believe that's when Cannon was like, "Let me take over," because she like she can't stand you, and you can't get through one sentence without this woman shutting you down. And so you cannot tell me that this guy, Robert Sylvester Kelly, was allowed to go sit in their courtroom and have due process, a fair trial. When you wouldn't allow the counselors to, and it's so wouldn't allow the counselors to do this and that. But I'm with Jennifer Bunjean. But she needs to put Greenberg in this equation too, because see, Greenberg was the lead attorney. You had 2 freaking years, and I kept saying, okay, this happened. That's when the COVID came, and I'm like, you know what? Maybe God is doing this because he, giving him the opportunity so his counselors can be able to go in and do their research and look up these lying ass people, and I just say lying because they got caught up on a bunch of lies. And I'm not going to take that back because they lied. They did a bunch of lying on their damn witness stand. Test the liars. It was a bunch of test the liars. But at the end of the day, hey, he didn't get a fair one. She need to bring up about Doug Anton engaging with the social media and things like that, and all this stuff going on. Just name every last one of his counselors that did some BS. Don't put that on Cannon, because when you say 2 months, it's like you putting it all on Cannon. Cannon wasn't there them 2 years through the BS. He trying to get caught up, and he was just trying to do everything he could do, you know, just compare 2 years of information to 2 months of information. Who is to blame? Then you have Greenberg on in an article speaking on, Cannick needed information. The code and was holding stuff back, and he had to give him some information. He had to call me and ask me. But if you said you was representing Robert, you want to see Robert win, no matter how pissed off you was at Nicole, because it seemed like Greenberg was just sitting back waiting for that L word. He was waiting on them to lose so he can go on Twitter and say, I told you so, and I had to get on there and cuss his gray ass out because he pissed me the hell off. Like it was showed that you are a professional attorney. And I said, this proves that you are a traffic ticket attorney for you to get on here and try to say, I told you so. But you didn't care about Robert Sylvester Kelly. F Nicole and whoever else you felt a problem with, because you took a lot of Robert Sylvester Kelly's money. And I still say, as an attorney, I would have been like, okay, Robert, he doesn't want me on the case, but I want to see him win. He done gave me a lot of money. He's close to me, and it just seemed like it was everything was a setup to me. Cause this is weird as hell, you guys. Cause it if you just look at it, it just something that's not making sense to me. When you have Dominique, right? Because not Nicole, but Jennifer, I think she brought up Dominique and Arline. And so my question is, and I don't know, I can't quite remember, but as if I can remember, it is coming back to me. They showed a video of Dominique and Arline engaging. They said it was three people, and they tried to say that was Robert. Okay, so if Robert wasn't face showing on that, who is to say that was Robert holding that camera? Who was to say he was holding that camera? Just go back, you guys, and just think about it. They said that the prosecutor showed a video of Dominique, and so whoever, like it was like rough sex or whatever the case might be. It was three people, but from what I'm hearing, that you couldn't see the third person. So if we go back and listen to what was said, just go back and listen to what was said. Dominique, well, Arline said on the witness stand that he knew Dominique. Him and Dominique worked at McDonald's together. That's very weird to me. So then Dominique gets with Geronda Pace. Geronda Pace is the female that had the fake ID that was close to Jim Daragatis, and the woman that was taking all the pictures at the trial is friends with Jim Daragatis. So what a freaking coincidence that you take all these pictures of a woman that is 16. She wasn't even 16. She was 14 going on 15 years old with a red ass wig on, chatting, Rob Free R. Kelly. Okay? And she gets in the courtroom. Okay, this woman gets in the courtroom and she made it where she was able for Robert to see her every time. If y'all can remember, okay, that one of the officers had to tell him to get in the elevator. Everybody left out, right? And then when it was time for Robert and his people to walk out so they can go eat, because they would go to the tour bus and eat, that damn girl will sit there and make sure Robert sees her face inside the courtroom, where you have to be 18 to be in that courtroom. Okay? And I'm talking about this chick. Let me see if I can pull her up. Let me pull this up first. That is weird to me. Y'all see that? That's not weird to you guys. Y'all don't see this? Y'all don't see that? Do y'all see what I'm saying here? This is totally weird. So this person. You know this person. Y'all worked together. How in the hell did all three of you guys, these people right here, end up connected? Now, Richard Arline, and then you had Dominique, Bubba, Joronda Pays. You can, I don't care what nobody say, but if you can't put this together, put two and two together, and see this is a bunch of BS, and this is very freaking weird. Okay, this is very weird. Then you have these two. How did she get linked up with Arline? Now, how did she get hooked up, linked up with Arline? All of these people was in that house working on trying to get money and con and do everything. It's weird to me. This is weird. And you can't say this is not weird. And then all of a sudden, you got Joronda Pace here with Susan Logan, and her and this man here are friends. Everybody is trying to go in and suck this man like a bunch of damn mosquitoes, okay? And I say mosquitoes because a lot of people don't know, but mosquitoes has killed more people than a war, okay? Just look that up. And I just find this weird. So you have this Dominique, this girl here. Just look at it. You have this one here. Ain't that strange to y'all? Out of all the fans that he had there, Jim Derrick Greasy friend only takes picture of, what a coincidence. An underage person that's pretending to be 18 years old, and they check her ID. She gets in there. Come on, y'all. Y'all, and all the way to now. Look at that. Look at those pictures. What are pictures of the other fans? Because I didn't find any. Look at there. She made sure that Robert seen her. She made sure she seen her face. Okay. Then when it comes down to it and bringing him down, I don't know if I'm still on because it's like I'm blank. I don't see myself. Okay, here I am. So look at there. A grown ass, a child at the bottom, a grown ass woman at the top. Look at that shit. Look at it. You cannot tell me that this shit wasn't planned. They tell her to dress up like a kid, cross her eyes like she's slow as hell, and get up there and act like a baby, but act grown when you're around Robert Sylvester Kelly. I find this strange too. You have this one right here. She was mad. She it wasn't a problem with her when she was walking around with Robert for how long? How many weeks? Wasn't a week? And he specifically told her what not to ask him in her interviews, and she did it anyway. And he called her out and confronted her about it, and she's been hot ever since. Then she's like, "Oh my God, the room," and it just make me think what was behind in the room. You okay? If you feel like this man was with little babies, you was there for a week, you ain't see no little babies, but all of a sudden now everybody is like, "Oh my God, the rooms." And y'all don't find it strange? Y'all don't find this right here strange. Every camera, Geronda Pace was in front of the news talking to everybody. And y'all don't find this strange. And you don't find it strange that this woman gets up there and testify in a RICO, and the judge wouldn't allow his counselors to grill this woman, call out Bubba and everybody else. They wouldn't allow that. You don't find this strange. Every picture, Geronda Pace. That's you have to ask yourself. Look at this. I still have them. I have all of it. I can go back. I go back and look at this stuff. The ringleader, money, right here. It was all about the money, right? It was all about the money, right here, right here. All about the money. And everybody, to me, was knew somebody that knew somebody that knew somebody. And I find it very, very weird. Then look at this. Look at it. You have this con artist that was in debt, talked about a bunch of DVDs or whatever, VH1, VHS tapes, whatever you want to call it. I just see a bunch of mess, you guys. I see a bunch of mess. Okay. Drea lied. She was unhappy, right? But I don't see no unhappy face. Y'all see her? She's right behind the girl that's in the front. That's Drea, smiling like hell with the entourage. Robert's on the other end, and everybody seems happy to me. You don't see nobody sitting up there not smiling, not happy. Come on now. Y'all see what I see? Then you have these right here. And that's what I call, this is like a part of a woman's act to me. And it's revenge and retaliation. London on the track. Then you got the sister mad because she was fired. Okay, a bunch of BS. Look at here. You got a dad that's pretending like he didn't know what was going on with his wife and trying to clean it up and make himself look good. But at the end of the day, you was part of it too. Because if you claim that you found out something in the next year, well, the next following months, like what, from 2015 to 2016, you find out you wasn't in a rampage or you wasn't upset then. And then in 2018, when Robert said no to a ding-a-ling deal, then all hell break loose. You done kidnapped my daughter, manipulated my daughter, brainwashed my daughter, slept with her when she was underage. Didn't have anything to say between 2016 on up to 2018 until he said no. And nobody's looking at that. Nobody's holding these people accountable for this bullshit. I see it. I see some strange ass stuff. I don't care what nobody say. I see some strange stuff.
Common sense. Don't forget the blogs. Forget how you feel about me. Hate me if you want to, love me if you want, but just use your common sense.
That's all. Just use your freaking common sense. Because something is not right here. Okay? Something is not right. I don't see nobody. Nobody hog tie. When I say y'all, I got so much stuff. It's just overwhelming. It's just so much. when I saw I have videos that I was making, it just is so much. And then I ended up like getting sick, and then I ended up getting COVID, and I'm dealing with that right now, going through some things. But I don't care what nobody say. Something's not right here, okay? Because even the trial, during the pre-trial, the motions, yeah, we were there. We were listening. We were on the phone listening to Judge Ann. And when these prosecutors say that Robert had the chance, you was a lie. Because when he tried to speak, what happened? Just like in Chicago, all of a sudden, Robert's mic, the only mic that's not working, so he can confront Greenberg, so he could tell them people about Greenberg. And they wasn't allowing him to say anything. You mute him in Chicago and you shut him down like he's nothing in New York. Take away his freedom of speech when he's trying to speak up for himself. Oh, you got counsel. Maybe you don't need to do that because the only thing you might say something you should know. I'm talking about these dirty ass damn attorneys. This is what I'm trying to tell you. But what she did, you take away this man's right as American citizen. Period. I don't. I see it, you guys. I talk about it all the time. That's why I'm just passionate about it because it is a lot of shit that's really strange. And people can say all day long, well, he made that decision. He was around people he shouldn't be around. He had them women up in his house and he shouldn't have had them up in there. A person should be able to live their lives the way they want to live it, the legal way, and not have to go through the shit he going through because you got these nappy dugouts up in they nappy dugouts all up in this man's house. I tell you, my nerves, baby. Lord Jesus, please help me.
Actual bias is bias, in fact, the existence of a state of mind that leads to an inference that the person will not act with entire impartiality. McCarran versus Poole. 2009 WL 4,575,393 asterisk 4 WDNY December 1st 2009 quoting United States versus Torres 128 F3D 38 43 1997. Actual bias can be found where a prospective juror admits partiality, or where the same can be inferred from his or her answers to voir dire questions. ID. Significantly, even where a juror expressly doubts his or her impartiality on voir dire, a finding of actual bias is not automatically mandated. Patton versus Yount, 467 U.S. 1025 1029 to 30. 1032, 1984, holding that ambiguous and contradictory testimony of 3 jurors was insufficient to overcome presumption of correctness owed to trial court's findings that the jurors would be impartial. The test for determining juror bias is well established.
Okay, Nicole, let me pop up. I'm sorry. I swear I'm sorry, but hell, the hell with it. Whew, Lord have mercy, Jesus. Okay, no, okay. You said y'all you been here. I remember Rita, you make dime, all y'all day ones. Y'all baby, I done took a pill. I'm gonna have to tell her, baby, this ain't working. I guess okay. I'm get my nerves together. I'm gonna get it together. I'm on it. I'm trying my best, baby. Oh Lord, let me take a deep breath. Everybody telling me to calm down. I told y'all. I said, okay. Day ones. Y'all remember? I'm trying to remember. Didn't they ask on that questionnaire? Have you did you watch Surviving R. Kelly? If I'm not mistaken, I know I got it downloaded somewhere, and I swear on the questionnaire they asked, did they have y'all watched Surviving R. Kelly? And they asked these people, did they watch Surviving R. Kelly? And then you didn't have these people, away from the TVs and the news and stuff. They was allowed to go home. So even if they didn't know anything about Robert Sylvester Kelly, or they didn't know anything about R. Kelly, you guys gave them the reason to go home and look at Surviving R. Kelly. Because when I looked at it at the beginning, and I'm like, damn, is this what's going on? And I'm looking at Geronda Pace. I'm looking when I first seen everything that went down, it was Geronda Pace on the reel. Wasn't it the reel? Was it the talk? Whatever she was on, and it was she looked like a little girl. So I'm all over the place. I'm like, wait a minute, what the hell going on? Because that's what made me like, I gotta see. I'm like, I gotta see what the hell going on, because something's not right. So you watched Surviving R. Kelly, and I know half of you did. We all watched it, and I had to watch it again. Then it was like more and more. I'm like, wait a minute. Now I know this is not him. Like, what the freaking hell? So, looking at it, like you thinking these people got their facts together and did their research and stuff, but they just threw people on there. Then you got drill long mouth, Kool-Aid smile ass, you know, up there, and then the brothers up there, and I'm like, wait a minute, what the hell going on? So I just had to keep. Yeah, she was working. This was her. It was the real. I got the picture. I got the picture of this thing. I watched this thing. I watched him, and she had her head down, and that what freaked me out. I'm like, what the hell is this? And so that's when I'm like, wait a minute. And when I saw that, I had to see what the hell was going on. And as a woman, women that know another woman, and you look and you pay attention, you just keep looking at everything, and you see it, you see some bullshit. And then I'm looking at this damn, what's her name? This Shanti speaking, the black room. Why? Was a puppet to the king name. A little, yeah, she the real. I know she was on one of them, honey. All I know, I looked at that, and I'm like, what the hell going on? Like, no, no, no. So the more we was researching, and we were looking, and we was finding all this BS, and so then when we see the lies and the BS, then we were like, oh hell no! So we got to get on here. We got to do something about this, because we see some bullshit. I'm telling you. Okay, so it was on there about surviving the lies. So you pinpointing and letting these people know who they gonna be going to court to see or for. When they gave them questionnaires and they read them questionnaires, they know about the shit with that went on about Robert. They probably like, damn, this is the R. Kelly case. I'm gonna make sure I get in this. This dude is this, and that. But I find it strange, because y'all remember when I was in New York, and I was like, forget this. I want to speak. I ain't got time to be doing this and that. I can shop later on to do whatever I want to do. Sightsee. I know New York. I lived in New York, and whatever. Let me talk to some people. Because y'all remember somebody was on there. I was on live talking about, no, maybe you shouldn't do that, because then they're going to be saying that you running around here and you're intimidating the jurors. I'm like, hell, they ain't even no jurors. I just want to know how they feel about this situation. And everybody that I spoke to felt like Lifetime was BS, and they felt like them women could have left, and they blamed the parents. Look at the parents. That was New York. So then you get 12 people plus some side pieces, jurors, and everybody voted against him. When the people I was speaking to, you had one that shouted at us, they was mad, but that was the only one I saw. Y'all was there when I spoke live to these people. And then the guy that was what was that? Was it a saxophone or whatever he was playing? And he was talking. He mentioned Gail King. He felt like there was some BS in a setup right there. And I'm like, this is weird. This is strange. And if y'all don't see strangeness in this, something is not right. And from my knowledge, and I just say alleged, Dominique was the one that freaked out and didn't want to testify. What are you hiding, Dominique? Was you part of this too? And trying to play innocent? And then everybody like, I believe she loved Robert and she cared about him. No, she was mad because he chose Azriel over her. Now I will pull them text messages up. She said she loved Robert. They had their ups and downs like any other relationship and couple, but he chose her. I guess like everybody was mad in the camp because this girl came and took over. Okay. Her mom taught her well. You go in there and you dominate. Now, this is what this said in the text. You better do it before somebody else gonna do it. And she sounds just like Elvis Presley wife, Priscilla, ex-wife, or whatever you want to call her. But this is some strange shit. They are like Robert is the only man that had multiple women in his home living with him, and they having sexual entanglements. Yes, CBD is just like they allowed the jurors to leave to go home. Their minds were already made up. Yeah. Matter of fact, I was looking at one of the security guards speaking on Puffy, and the one that went to jail behind Puffy, and they paid off the jurors so they can is it Shine or whatever. I think it was, well, his name was Shine. He went to prison behind Puffy. But remember, they were saying held capture. That's what I'm saying. Cause I was looking, cause when they was talking about it, I'm like, wait a minute, y'all talking about somebody kidnapping stuff, like some girls, he holding some girls captured. Like, I'm like, this is a lie. Because we're in the United States. You know where he's at. He had a concert here. Like, it wasn't too long that he had a concert here, not too far from where I live. And I was like, I have to go. I'd make sure I go. And that's when the allegations was out, and people still went. Yeah, I mean, come on. And then you guys, I think it should be a law. Take that, take that, take that, take that. Press play. It needs to be a law. Um, just like with normal people. You don't see them talking about it all the time on the news. You don't see that. You don't see them just constantly talking about it. You don't see them doing documentaries, and it wasn't even a documentary. You don't see them doing a film about a person, and you getting ready to try to indict a person, and then after indictment, then you constantly put these people on the TV. It should be a rule. It should be a law So a person can have their due process and a fair trial. Give them a chance. And they did not give him a fair chance. I don't care what these DAs saying, they are telling a damn lie. So they feel like this Robert had a fair trial. When you had the surviving lives, the baby mammy and the pappies and mammies of these women that they coerced to go and play with their own nappy dugout with this man, lie about their ages, have fake IDs and stuff like that. And I say it once again. If this man like babies, as y'all say, why y'all got fake IDs? Why you gotta have your mama to lie about your age? Jerronda Pace mama was part of this too. Because Jerronda Pace mama didn't give a damn. I just need some money. And I heard that you can sue him quick, fast, in a hurry. But I find it very, very weird. The Roberts trial in 2008, you have Jerronda Pace, a picture out of everybody are underage. Are underage. If y'all remember the girls that was like, no, he's a good man and this and that. I still got that recording too. She looked like a girl. She looked like a little girl. So why y'all weren't taking no pictures of her? This girl, Jerronda Pace, had a motive. All of a sudden, you get with Dominique. Dominique was friends with Richard Arline. She probably was screwing him. And then you have this Jerronda Pace turning out Dominique. They screwing. And ain't nobody talking about that. Ain't nobody talking about the screwing. So then you got Cunningham. You got the Cunningham girl. Get up there and he say she say kind of thing. And this was a he say she say trial. Like I told y'all. He say he say she say trial. Cunningham gets up there and and her testimony was about a deceased woman that said that nothing happened. Robert said nothing happened, but I don't see them having her up there speaking on her situation. They eased her situation in. She claimed that she screwed Robert when she was 14 years old. But is anybody asking a question about these girls up in their nappy dugout at 14? Y'all remember Cunningham? Y'all remember she said that Tiffany Hawkins and two other girls was there. She wasn't friends with these people. She didn't know these people. But then she turned around and said she was friends with Tiffany Hawkins. So I'm like, wait a minute, you lying on here. Nobody see you lying on the witness stand. You testifying. You said you didn't know him. But you said first, you said that you and this girl was friends. You and Tiffany Hawkins was friends. Then you say you go to the studio. So you go to the studio with a backpack. You said each girl was in the corner. I was scared because I thought they was going to jump on me. And then you say Robert lays down and you get on top of him, right? Say you gets on, she said she gets on top of him and she straddled him. And then she asked him, did he have a condom? I don't have a condom. And 14-year-old grabbed the condom out of her backpack. So you went there with the intention to screw. Now this is what you said. These people, I told y'all they made lemons out of lemonade. Okay. They made they made lemonade out of lemons, okay, with this case. Because all I saw was a bunch of he say, she say, okay? But y'all showing video, okay, where the baby's at. You grown people screwing. Wasn't her number one rodeo. So y'all remember that. But I'm like, okay, they didn't add this Cunningham in the case because it was a damn lie. But they did it to persuade these jurors. So, but nobody's asking. Nobody. Because if I was a juror, I'd be like, wait a minute, what's up with these damn happy, smiling faces, just young and just riding dinglings? Where their parents? But they never questioned it. They never said this man pulled them and jerked them and jerked off their clothes and put a gun against their head and forced them to up their nappy dugout. Period. And I'm a female. I'm a female, and I'm gonna keep it real. Just like Asriel, she gets up there and say, "Yeah, I got on top of him, and I let him eat my behind." So, but you saying you a virgin, right? You say that you're a virgin. So you have, as a virgin, a teenage virgin, that girl said, go, I'm telling you, go back and look at the transcripts. Cunningham said she had a backpack. She was scared. She thought them girls gonna beat her up. And Robert gonna have them girls beat her up, and she got on top of him. But still, at the same time, okay, all these girls, they doing all the work. But as a virgin, you just sit back and think about it. My channel is no kids, okay, not for kids, because this is what we talking about. We talking about, intercourse and stuff like that. You're not going to, your first time having sex as a virgin, a young virgin, you ain't gonna allow nobody to be kissing on your boo boo. You know what I'm saying? You're not gonna allow that. You're not gonna feel comfortable. But you got on him happily and didn't feel strange about you getting your butt ate up. Because a virgin and a young virgin, an older man, they're gonna do it the other way. They're gonna do the vagina. She was by no means a virgin. That's what I'm saying. These girls, and then you get on there and you straddle a grown man at the age of 14, and you didn't have no problem doing that. You didn't reject. You didn't say you was scared. You asked him, did he have a condom at the age of 14? And y'all don't see nothing wrong with that? Come on. Somebody else been playing in that nappy dugout. Because a virgin is not gonna just no. That's not gonna be the first thing I'm gonna allow a person to do to me, being a virgin. Because I'm gonna be uncomfortable even with the oral stuff. I'm gonna be uncomfortable with the penis. My butt would be the last thing as a virgin, and even now, to allow. Nobody finna be kissing up in my butt. So did no one just ask the question like, this is some strange stuff? These girls run around here talking about they virgins and everything, and they run around here, doing this. I'm about to lose my voice again, you guys. Like I said, I'm still not 100. My throat be hurting all the time. I lose my voice. But y'all don't see what I see. Yeah, y'all don't see that? Do anybody want to come on? I don't know if somebody else is live. I don't know. I don't even look and see no more because they don't do that for me. But hey, y'all don't find this strange. Let me see what else I got. When we need money for bail for Baltimore, since I asked Jay Z as oh this dream, I don't rise. I've done private, and if it was that easy, no one would know who the Clarets are. See, when we first got on the scene, there was a text message from Angelo. This is how I treat racism. White children. When she was trying to expose my story with Leo from. Okay. There's Dream Hampton. I have a lot of stuff. I just have to pull it out, you guys. But I'm just trying not to get agitated right now because this stuff's about to agitate the hell out of me. But we almost 2 hours in this. We'll hear a little more. I'm pretty sure everybody else talking about it, so it is what it is. So today, I just hate how we can't get our phones back till 9. I wonder why y'all remember this. This was in December 2014. She had a show at Disney, right? Why they didn't show this about the phone? That's what celebrities do. You know what I mean? Celebrities not gonna sometimes not gonna let you have their phone, your phone. So why they didn't show that? Oh no, she never said she left out of the punch rod, making wide leg bleeding. That's what I'm saying. Oh, this is weird. I'm sorry, y'all.
The
Y'all
test
know.
for determining juror bias is well established. To hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if a juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Diaz versus Conway, 2008, WL 2,461,742 at asterisk 27, SDNY, June 17, 2008, quoting Irvin versus Dow, 366 U.S. 77. Even where a juror previously expressed some reservations about his ability to be fair and impartial. If the juror later expresses during voir dire that he will try to decide the case based on the evidence presented, that assurance is generally sufficient. United States versus Town, 870 F2D 880 885 2 DCIR, 1989. Therefore, to prevail on a claim that defense counsel was ineffective in failing to remove or challenge a juror during voir dire, a defendant must show that the juror was actually biased against him. 8. At asterisk 20, without a finding that the juror was actually biased against petitioner, prejudice under Strickland is not presumed. C. Analysis. The defendant's ineffective assistance claims are wholly without merit. He cannot establish either prong under Strickland and his motion should be denied. The defendant first makes 1. Generalized assertions that trial counsel failed to conduct any meaningful voir dire of prospective jurors to ensure they were free of bias or prejudice, mem. At 11, and 2. Unfounded and vague claims that trial counsel should have, for example, probed more deeply, mem. 7. Inquire further, mem. At 9, or completely questioned, mem. At 12, certain jurors. These claims are wholly belied by the record, which shows that trial counsel actively participated throughout the voir dire process, submitting additional questions and asserting challenges for cause, both in writing and orally, in some cases successfully, as to various prospective jurors, including those prospective jurors whose impartiality may have been in question. In addition to the defendant's written for cause challenges with respect to the approximately 50 prospective jurors initially qualified after the first 2 days of in-person voir dire, The defendant requested that the court make further inquiries of approximately 19 prospective jurors, including additional questions related to the prospective jurors' opinions on the Me Too movement and related topics, as well as their knowledge of the defendant and the nature of the charges. C. e.g. BDTR 41, 46, 5556, 57, 128 to 29, 168, 180, 215, 223, 242, 200. On various occasions, after hearing certain prospective jurors' responses to the follow-up questions, trial counsel did not challenge them. However, with respect to certain other prospective jurors, for example, prospective juror knows 129 challenged, and the court ultimately excused the prospective jurors for cause based on their responses to inquiries related to the Me Too movement. VDTR 128 to 20. Trial counsel's inquiries on these topics clearly reflect that they considered the very issues now raised by the defendant when making for cause and peremptory challenges, and made strategic decisions in certain instances not to challenge a particular prospective juror based on their responses to inquiries from the court and the parties. Guerrero versus Payon 2010 WL 2,545,818 * 21 EDNY June 21st. 2010, reasoning that the fact that trial counsel's decision not to challenge a juror for cause was strategic may be evidenced by trial counsel's use of for cause challenges on other prospective jurors. Figueroa versus Heath 2011 WL 1,838,781. 2011, finding that counsel's active participation in voir dire indicates that any decisions to challenge or not to challenge jurors were made as part of a reasonable trial strategy, rather than as a result of counsel's failure to provide effective assistance. Warwick v. McLaughlin 2004 WL 1,006. 2004, rejecting ineffective assistance of counsel claim regarding voir dire because the record reflected that defense counsel was actively engaged in the voir dire process and an attorney's determination to accept or strike a prospective juror was a strategic or tactical decision. Internal citation omitted. Rodriguez versus Breslin 2009 WL 424,738 * 9 EDNY February 20th. 2009, finding that counsel's decision to peremptorily challenge 8 jurors lent support to conclusion that decision not to challenge allegedly biased juror was part of trial strategy. Nova versus Ercali 2007 WL 1,280,635. This suggests that counsel deliberately chose not to challenge another juror as part of trial strategy that might be considered sound. Internal quote, Case 1 not 10. Nor has the defendant shown that he suffered any prejudice. He provides no tangible evidence of actual bias, relying only on speculation based on the challenged jurors.
Okay. Did y'all hear that part? I know you late. You are very late. Did y'all hear that? I want to rewind that part back. Let me let y'all see this. I want to see what they said. Let's go back, and I just want to say something on it.
He provides no, nor has the defendant shown that he suffered any prejudice. He provides no tangible evidence of actual bias, relying only on speculation based on the challenged jurors.
Okay. Relying on speculation, right? Isn't this what they did? They wanted them to rely on speculation. All of that stuff was hearsay. There was speculation. No evidence, nothing. I'm like, where is the evidence? And then when they were talking about Alea, and they said a receipt. Good night. Yeah, I'm gonna have to go too because it's like almost 2 hours in it. Um, I don't know. It's just a lot to talk about. So it's just like I don't know if you come on every day. Do I come on every day, do like 30 minutes to an hour just talking about this stuff? Because it's like so much. Just break it down. Like if I'm gonna say something, talk about the Cunningham, but it's just like all of them are connected. Everybody is connected, but it was speculation. They was talking about a receipt. They said they found the receipt. That was one of their evidence. That was 35 what 100 discovery. That was part of their discovery, a damn receipt. And every text message was part of their discovery. Okay. So I'm thinking they had something. And I'm looking like, what? Okay, y'all pushing a cart full of text messages. They had that cart with them papers, and they was trying to make the people think that they had something going on. And that trial was easily winnable. But you had people like Judge Sidebar that didn't allow these people to do what they was paid to do. And y'all know it. Y'all remember. Y'all remember when every time Canick tried to object, I remember Thomas as well with the jurors. And they wanted to question one, and they spoke about one certain person, and Doug and Doug, what's her name? Dunley or whatever. She was like, whatever. No. So if you compare, go back and compare all the exceptions that she allowed these DAs to do whatever they wanted to do. Because I went back and listened to what she said. Oh, the mice have came out now, so caution and free cheese is no longer there. Now they are we're trying to make no holes. The whole damn case is built on speculation and hearsay. Not enough, not good enough. That's what I'm saying. We spoke on that. I just have to get the videos out. I really have to. But you guys, when I lay in the bed, I'm not gonna lie, I be totally like drugged up. I'm not gonna lie, I be drugged up. So what I want to do is just try to like every day, and I'm gonna try my best, you guys, like do at least 30 minutes of a breakdown of what happened in that case, because I also wanted to get the transcripts up and of the hearings and break those down. So I'm gonna try to send for some transcripts of all the hearings, so we can break down the stuff Judge Ann was doing. We already know she was sidebarring and sidebarring and sidebarring, and stuff like that. So I'm gonna stroll and see what they talking about, y'all. I just can't take no more. And so the head guy questionnaire, they talking about the jurors. They was talking about the jurors. Juror number 3. The transcript read, any reason why you wouldn't be able to follow my instructions on the law? The word. Uh, I'm kind of woozy, you guys. I'm sorry. I did take my medicine before. Let's see. Because I thought they had faith on here. How many pages is this? How many pages we got? 45. Y'all, that's a lot. Yeah, they talking about sleeping with girls. Okay, let's see. I gotta go back and look at that questionnaire. HIV. One person was upset about some diseases and stuff and said that they family member had, and they asked a question about that, but she felt a certain way, and they asked, bring that into court. And it was like, no, no, I'm gonna follow the law. And so Judge Ann allowed that person to be picked. And I don't understand it. It's a lot of pages. I can't take. I'm pretty sure our girl Miss Tracy gonna read it. I was just trying to see what was in here that they constantly talking about. Okay, they talking about Aaliyah. The defense claim the trial counsel should have pursued juror number 4 dismissal. During voir dire, likewise failed Strickland given the trial counsel performance was not there was no prejudice. Number 4 refers some knowledge of the defendant and proposal of her marriage. Questionnaire 2023, she advised that she was able to put any such knowledge aside. Y'all see this what I'm talking about right here? I can't. Let me try to blow it up. I was trying to find how many men's in prison now that has been falsely accused. Too many, a lot of them, baby, because a lot of. There's so many. This is the one. This is one of the questions. Let me see if I can just get this pin apart right here.
Notably, the defendants claim that trial counsel should have pursued alternate juror number 4's dismissal during voir dire. Likewise, fails Strickland given that trial counsel's performance was not deficient and there was no prejudice. While alternate juror number 4 referenced some knowledge of the defendant and possible rumors of her marriage to Aaliyah, question 29 to 33. She advised that she was able to put any such knowledge aside and decide the case fairly and impartially. BDTR 266 to 67. During voir dire, however, trial counsel requested that the court inquire further regarding alternate juror number 4's stated history and experience with sexual harassment, question 46, and indicated that he was going to challenge her. BDTR at 270. However, upon hearing her answers to the court's additional questions on this topic, trial counsel made the strategic decision not to challenge this juror. BDTR 270 to 72.
Okay, you remember? See, I remember that. Baby, can you give me my drink? I'm about don't leave me because I just feel like I'm on cloud nine. This medicine is in me, like it's hit me right now. Can you give me that water? Y'all remember that one? That's one of the ones I was talking about, and they allowed her to stay there. I remember that like good is whatever, but y'all, I'm gonna have to go. It's a lot. I'm gonna get my notes together. I'm gonna get the video together. Um, Let me see if it's another one. Cause I remember, I think, matter of fact, it was either Thomas or Mr. Canick spoke on that, and all these people had to do was like, oh, I'm gonna be able to get up there and not judge a person on what I know. They allowed those people to go up there, so no. And she can't. I think I don't think she can call out Judge Ann right now because this is the woman that's gonna make the decision. But I know Jennifer Bungie want to go at her. I think in the last motion she did mention something about that. Let me check it because I think in Jennifer's motion she spoke on. Let me find it real quick. Because she was like, wait, because I think I clipped it out and I was going to put that part on Judge Sidebar. I was going to paste it on Judge Sidebar because I think she did mention something about the judge wouldn't allow something. Seeking prior material. At the final pre-trial hearing, defense counsel concurred that he did, in fact, know who. Okay. Bonjean is telling Judge Ann on here. Let me see if I can bring it up. Let me get out of this one. Which one is this one? And then we can go. But Jennifer was saying that the counselors were saying that, about Robert and, things like that. Let me put it up real quick. Y'all, Mister, you don't hear me? I need some. I was asking you, can I have some water? Let me see which file this is. Let me see. Is this the one? I think this is it. Let me see. Yeah. Let me blow it up. I don't know why my thing is not letting me. Let me see if I can blow it up. Not a fair trial. I think this is the one we should.
8 important.
Okay. Okay. I think this is one. On August 6, 2020, the defendant counsel filed a 2-page settlemental government motion admitting of the bad act about the trial. Defendant counsel filed a handful of letters objecting to the introduction of certain bad act evidence. Those objections were largely overruled. Yeah, this is what she was talking about. But she was trying not to say it in a way to, say anything about Judge Ann. So let me find what I was talking about with. Let me go back. Thank you. Don't leave me. I'm telling, please. Open the hallway. It's open. Thank you. You hear me? Come back down here and check on me. Huh? I'm trying to find this guy. What I have to look at it again, and then I my thought will be back. Okay, basically, let me see if I can break it down because I think I lost the page. Witness, final trial hearing, defense counsel. Witness, settlement, and throughout the defense counsel filed harmful letters. Lemony granted motion in 2 months defense trial as the defense team focus on fighting. Y'all, excuse me. I apologize. I really apologize. Um. Okay. Since I can't find it, I got it back in my head. What Jennifer Bunjean is saying when Robert said that he knew all the people, he wasn't saying that he knew them, that he knew them. He was saying that he had all the discovery. So he knew who was going to be coming to trial. And so his counselor said that he have knowledge of these people. He know these people. And actually, Robert was trying to say that he had all the, discovery. So he know the people that's in the discovery. That's what I was trying to look for. So she gave a great breakdown on that, and this is what I was actually trying to look for. I ought to just go ahead and let's see. I'm gonna go ahead and read it. Oh, I gotta go on. Okay, I gotta please save. It's saved. Okay, I'm gonna have to forget it on. Okay, motion, new trial. Okay, let me see.
One introduction defendant's trial was engulfed by irrelevant and excessive bad character evidence that added little to the jury's assessment of whether defendant committed the charged offenses. Indeed, the 6-week trial was comprised overwhelmingly of uncharged bad act evidence that served no legitimate evidentiary purpose. With the court's blessing, the government subjected the jury to a massive repugnant conduct for the primary purpose of depicting defendant as contemptible, sexual deviant. The government defended the introduction of the evidence as relevant to the means and methods of the enterprise with nary a word of Rule 403 considerations. For reasons argued in defendant's Rule 29 motion, the government's evidence of an enterprise was insufficient as a matter of law. This case was not about an enterprise, it was about the conduct of one man who the government sought to punish for his alleged history of mistreating women. As such, the mountain of bad act evidence offered in this prosecution was nothing more than inadmissible propensity evidence. Because defendant was forced to defend against dozens of uncharged claims of abusive and sexual misbehavior, much of it lawful albeit unpalatable for some, defendant was stripped of the presumption of innocence and denied a fair trial. But that is not all. Defendant was denied effective assistance of counsel when his attorneys failed to file adequate pre-trial objections to the introduction of the mass of overly prejudicial propensity evidence and routinely failed to lodge timely objections to some, although not all, of the damning bad act evidence. In sum, defendant's trial was little more than a reenactment of the one-sided docuseries Surviving R. Kelly, which several of the jurors had viewed before stepping into the courtroom. It is a wonder that the government did not simply offer the docuseries into evidence. With this case 2 backdrop, defendant was powerless to defend against the charged offenses, for which there were viable, even winning defenses. Defendant was denied his constitutional guarantee of a fair trial where the jury heard excessive, minimally probative evidence of contemptible conduct that was introduced solely to inflame the passions of the jury and punish the defendant for decades of unchecked bad behavior. Relevant facts in the 2 months preceding the start of defendant's trial. His defense team was focused on fighting one another and preoccupied with litigating a Curcio hearing on account of his attorney's disabling conflict of interest. Not surprisingly, defendant's trial team wasted valuable time and resources focused on this side circus rather than preparing a strategy for defending the case. At the defendant's request, this court granted an extension for the filing of motions in limine until July 23, 2021. DKT Number 131, on July 23, 2021, the government filed a whopping 55-page Motion 1 seeking to admit a heap of prior bad act evidence. DKT Number 133, defense counsel filed no motions in limine. Incredibly, defense counsel failed to preclude any uncharged bad act evidence that was produced as part of the government's 3,500 materials. On July 30, 2021, defense counsel filed a written objection to the government's motion in limine regarding the introduction of prior bad act evidence, largely on timeliness grounds. DKT Number 145, The response contained a general objection to the evidence is untimely with no meaningful relevancy. Objections are Rule 403 analysis. Inexplicably, defense counsel did not seek a continuance of the trial to investigate these alleged surprise witnesses but merely asked the court to strike them. 1. This motion was in addition to a separate 39-page motion in Lamine DKT. 3. At a final pretrial hearing, defense counsel conceded that he did, in fact, know who the other bad act witnesses were and was familiar with their allegations. Defense counsel conceded that he was in possession of all 3,500 material and had received supplemental 3,500 materials from government. On August 6, 2021, defense counsel filed a 2-page supplemental opposition to the government's motion to admit other bad act evidence. Throughout trial, defense counsel filed a handful of letters objecting to the introduction of certain bad act evidence. Those objections were largely overruled. The record does not seem to reflect objections to much of the uncharged bad act evidence offered by the government. Argument: defendant was denied a fair trial when his jury was swamped with a massive, minimally probative, cumulative, and unduly prejudicial other bad act evidence, some of which was admitted without objection in violation of defendant's Sixth Amendment guarantee of effective assistance of counsel. With virtually no limitation, this court permitted the prosecution to inundate the jury with excessive bad act evidence, mostly under theory that the evidence was relevant to the means and method of the enterprise. Means and method justification for the introduction of copious amounts of bad act evidence is gravely flawed because the government's theory of an enterprise is flawed. Where the enterprise consisted of nothing more than the purported sexual misbehavior of the defendant unconnected to the activities of a discrete enterprise, the means and methods relevancy justification is meaningless. As argued at length in defendant's Rule 29 motion, the government failed to prove that defendant was distinct from the so-called enterprise. No matter how much repellent evidence of Case 119 CR002H6 for sexual indiscretions or abusive behavior the government accumulated against the defendant, the fact remains that it was the defendant, and the defendant alone, who engaged in those affairs wholly disconnected to the affairs of a distinct enterprise. By characterizing defendant's purported decades-long history of abusive conduct toward women as an enterprise, the government not only avoided statutes of limitations but was free to introduce any unkind or abusive act of a sexual or non-sexual nature as evidence of the enterprise, conveniently avoiding the rule against the admission of propensity evidence and the limitations set out in Fed. R. Evid. 404b. Notwithstanding, this court was still obligated to conduct a meaningful Rule 403 analysis, which it failed to do. Rule 403 authorizes the exclusion of relevant evidence when its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issue, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The United States Supreme Court held in Old Chief that unfair prejudice as to a criminal defendant speaks to the capacity of some concededly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offenses charged. Old Chief versus United States 519 U.S. 172, 180, 1997. The committee notes to Rule 403 explain, unfair prejudice within its context means an undue tendency to suggest decision on an improper basis, commonly, though not necessarily, an emotional one. Advisory Committee's notes on Fed. R. Evid. 403. As Old Chief observed, courts that follow the common law tradition almost unanimously have come to disallow resort by the prosecution to any kind of evidence of a defendant's evil character to establish a probability of his guilt. Not that the law invests the defendant with a presumption of good character, but it simply closes the whole matter of character, disposition, and reputation on the prosecution's case in chief.
Okay, we're gonna stop it on that part. Oh, I thought I had it blown up. I am so sorry. I thought I blew it up. This is the part. Where am I? I don't know what I did. Oh gosh, what did I just do? Mm, what did I just do? I'm sorry, y'all. It's on another screen, and I don't know what I just did. I'm just pushing stuff. Okay, is this it right here? Yeah. I want y'all to see this here. Why I don't see it? Do I have the right page? Oh, I don't know. I thought I had the right page. Oh, y'all, I swear I don't know. Anywho, I was trying to show y'all. That's what we were talking about. Y'all remember we were talking about Robert. She wouldn't allow, Judge Ann said this. I'm gonna find the transcript. I'm gonna find which one. She wouldn't allow, she said she wasn't gonna allow them to show any videos of him um in good character. She wouldn't allow them to, she told them she don't want um any talk about him giving to charities. You know, they can't play his music. They couldn't show anything because y'all remember. I'm like, damn, Judge Ann Wood, y'all just want people. Only thing is allowed is to come in and talk about him and make him look like a monster. And they wouldn't allow. She didn't allow any of that. Did that make any sense to you guys? That you couldn't even show like this man donating to better women's shelters, which he did in Chicago, giving clothes and feeding people and paying people's funeral costs and things like that. And they couldn't talk about the lady. They couldn't do any of that. So he didn't have a fair trial. And what did the councils have to fight against when everything was being denied? No, you can't do this, and no, you can't do that, and no, you can't bring this up, and no, you can't question the father of Azriel Clary or the mother. And if you notice, the DA, the only person parent they mentioned was Faith Rogers because they supposed to be the Christian. Yeah, their back was against the wall. So I mean, what could they do? Because I remember when Canick, I think, matter of fact, he was actually, excuse me, you guys, I gotta, matter of fact, Canick called her out, and I know I have it on a video. I know I got the transcript because I cut it. I did a screenshot and I cut it and I put it on a video. But he said, "Are you going to continue to do this?" And objections and overruling us or cutting us off, basically not in those words, but he questioned her on that. He questions Judge Sidebar, and when he was going at their neck, um we need a sidebar real quick, and just to call them to the side, because that I remember that was who the hell, I think it was Azriel Clary. And Judge Sidebar stopped him grilling her ass just to say, "Oh, I just want to know when we're gonna go to lunch." I'm like, Heifer, why are you always cutting him off, but you ain't cutting them women's off? And then if the girls, the DA messed up on a question, she will fix the question for them and ask. She was asked, talking to Azriel, asking the question. I said, you might well get your ass off the podium and get your ass down there with the DA. But she will always discipline the defense team. I'm gonna have to go back and read them transcripts, baby, because I know I was a mad sister. Excuse me, y'all. My lips is dry. Woo, Lord have mercy. But what you call it? Cause see, he supposed to be coming on here. You know what, Mr. J? Mm-mm. You wrong for that one. He supposed to been coming on here taking over the show because I knew I was gonna be medicated down. Stop making some people of color men poster child of all bad things. That's what people doing. They using him as a punching bag, and I told him, I'm like, hell, I went through stuff, and I refuse to sit here and use Robert as a punching bag, you know, because why don't y'all call out the ones that did something to you? But yeah, it's long. I'm pretty sure Tracy gonna read through it. Tracy, I know you're gonna read through it. I hope she go live when she read through it, because one of the pages on here, I'm sorry, is oh, happy 12. Okay, well now you do your thing. Be a parent and enjoy the night is almost over, and I know she wanna spend time. Oh my God, happy birthday. Tell her, Auntie said happy birthday. I gotta get her something. I gotta get her something. What she want? Ask her what she want. I get her something. Now you focused on them, cause you know I talk my ass off. We are 2 hours in this, and I gotta get myself in order. Cause I be coming on here and I go bird. Because I was saying I said I'm gonna be reading this, listen to it with y'all. I haven't had a chance to read it. I think one motion is 100. How many pages? Okay, she did 12. Why do I have three of these up? Okay, she did 12, and oh my God, 109 pages. So who is this? Who? Okay, I think it's the government. Yes, indeed, y'all. They 109 pages, baby Tracy. I will be over there to listen to this 100 because I ain't got time. Wait a minute. Okay, a backpack. His inner circle carried Kel's backpack, which contained, among other items, iPad that he used to record. Okay, he can record if he want to record, and they know he was recording them. They could have said, "I don't feel comfortable being recorded." So what's wrong with that? And they talking about, let me listen to this, y'all. See, I ain't got time for these prosecutors and stuff, because I know me. I don't want to go out. His inner circle carried a damn backpack. His inner circle ensured that Kel attended business meetings. Okay, he's supposed to attend his business meeting. Oh Lord, baby, I can't. I ain't gonna be able to make it through this. I'm not. Let y'all hear this.
Kelly's inner circle also assisted Kelly in his personal life. For example, Kelly's inner circle distributed slips of paper with Kelly's telephone number to women and girls. GX 401 T 1507 to 08 1510 Arnold.
What
Kelly's
happened?
inner circle selected women and girls to join him backstage and at after parties. T 771 Jane 2130 Faith 2552 Alexis 2819 Anna.
What a damn thing.
When Kelly used the Chicago track studio and when his studio was housed in the basement of his residence in Olympia Fields. His runners regularly picked up his female guests from their homes, nearby train stations, and airports.
He picked up his female guests. So damn what? The hell? So damn what? He picked up his guests. He was man enough and nice enough to pick up their damn asses. They didn't have cars to come. He was nice enough to send for they broke asses, and they came. Okay, so I'm just saying. People say what they want to say. Yes, I'm a female. They gave him the nappy dugout. He did not rape anyone. He did not force anyone to do anything. They was running behind that man money. He was the one being used. Okay, they didn't want Robert, especially Faith. She did that to child because she was mad at that man that pulled her hair, cheated on her, got a baby by her. Damn baby mama stabbed her ass and shit like that, and she was mad. I was trying not to cuss. That's why I said I gotta let Tracy read this stuff right here because this is what I end up doing. Going the hell off. Going off. If the man want to carry a backpack, I got a damn backpack. I carry a backpack with my damn devices in there. I got this in here in my backpack. I have this device. I have this device. I have this device. I have this device in this thing right here. So it's a sin. See, that's what I'm talking about, y'all. I have a backpack. I have different backpacks. I carry my backpack. So it's a sin to carry a damn backpack. He got money in there, and a lot of people carry backpacks full of their stuff. And if he want to record to make sure these thoughts said that he ain't raped them, then that's what he has the right to do. Okay? So y'all making it a sin. Y'all look these things right here, y'all. These things right here. Mm-mm. These little three things right here, baby. And that black man right there, I'm so disappointed in you. Biden, y'all do y'all research on that man. Joe Biden. He was the one put that man in office. So he came in and did 109 pages to help these three blind mices on Robert Sylvester Kelly because this is a big case and they don't want to lose. I'm telling y'all, they don't want another Bill Cosby. They do not want another Bill Cosby, okay? And so these people gonna do whatever they need to do to make sure that they keep him locked up and that nobody overturn this here because this is supposed to be a victory win for these three blind mices, and it was full of bullshit. I don't see how. I don't know. This is my tablet that went dead on me. Yeah, I can't find it. I was trying to find this man. Joe Biden, do y'all research. I'm gonna try to put his name up there. Y'all do y'all research. I noticed it. Even with Bill Cosby, the district attorney, that's a Democrat, and he was appointed by I think President Obama appointed him. And so if y'all pay attention, they trying to bring down real men and shit like that. And my man was talking about that yesterday. He said it's some effed up stuff going on around here. He said what these people trying to do, they trying to give us these shots. They trying to drug us up, and so we won't be able to, increase our population. And so, see, you see what they doing with men, okay? Real men. You see what they did with Jesse Smollett. But he didn't deserve to go to jail anyway, because he really didn't do nothing, to me. All he did was upset some megas, and that was it. He did a host and to try to, make himself look good or whatever the case may be. All he has to do is just pay them down people back in Chicago, they money they spent trying to go around and help him and shit like that, and going about his business. But no, he does not deserve to be in jail. So I'm not mad at him about that, but look what happened. They happily let the ABCs up out of there, but they holding down real men that's gonna help try to populate. It's like if you're a man, hell no. Hell no, we have no mercy for you. Y'all better pay attention to that. So you got a African American man, with multiple girlfriends, which he told him I got more than one. woman, and I'm the type of woman like this. I don't care if you rich to be rich and you the billionaires of all billionaires. I'm not sharing you, damn it. I'm not sharing you. So at the end of the day, he was that's his prerogative. If he want to carry a backpack, he could carry a backpack. If he want to carry a backpack with an iPhone, that's his damn business. Just y'all are what you call it, conservative. These women are conservatives. You know what I'm saying? They are the norm, in which they don't understand. They don't understand. They look at living their lives is expecting his life supposed to be like theirs. Like my man supposed to only have one woman. I'm not, that's his life, that's his business, but I know what I'm gonna allow. I'm not gonna allow my man to have an extra woman. And I'll be damned if he come to me and say, I have a woman and I want to, I want to have a threesome. He gonna get his ass cussed the hell out. But this is his prerogative. This is what he lay down and let these people know. Hey, listen, I ain't trying to be tied down. You can hang out with me, but when you come, I got multiple girlfriends. He tried to do that with Sarah. So what he didn't drag her into no bullshit. He told her he slided in there. He was like, "This is she a good one, but I'm gonna have to be a little slick and slide it in there." Robert tried to slide it. I got some extra girls, women. So and Sarah was like, "Oh hell to the no, no, no! I'm finna go on back over here with my Iranian folks and Indian folks, and you deal with this over here, cause this is not me." That's all the other ones had to do. But he didn't drag anyone. Everybody left out with their toes, their ears, their tongues, their fingers, no broken bones. And they talking about a damn backpack. Talking about the entourage carried a damn backpack with a damn phone. What kind of argument is that? I'm finna go, y'all. I'm finna go. We'll talk about it. We'll talk about it, but I'm gonna go. I can't talk about this no more because I went the hell off. I'm trying to work on myself. If the man had different women, that's his damn business. That's all I'm saying. I'm tired of people sitting up here trying to make it like this man did something that no other man has done. My man was a player. He thought he was trying to be a player. He thought he was the shit. But you ain't doing it no more. You retire. You gonna put that player retirement up because I ain't having it. But hell, a lot of them did it. Okay, but he told them about it. So what? I don't have no sympathy for these thoughts. They thought. I'm sorry, they thought. They used that man. I'm finna go. Y'all have a blessed one. I tried to do good, but I can't take this no more, y'all. I'm out of here. I watch Tracy. I'm gone. Go out.
It's not too deep as the ocean goes deep.
I'm talking about my son's life. And I'm talking about the lives of other black kids. Do what the hell hell you want to do. Go ahead, but you can't silence me. But you are not going to silence me.
We know that the government is running.
Prove it guilty! Due process!
Due process again! Due process again! Due process
Wellness check!
Hey everybody, I'm your host, Texas Black Diamond, and thank you for tuning in to Texas Black Diamond ENT.
Yeah, I'm up out here. Jay, you wrong, cause see, you supposed to be taking over this, cause I already told you what gonna happen to me. But hey, y'all, woo, Lord have mercy, God bless America. Y'all see, I had neck brace on and everything. I ain't letting that stop me. Just like now, I ain't letting that stop me, baby. I got so much going on, but hey, I'm telling y'all, I cannot be silenced. Just like I told my man, I'm like, I'm not gonna be silent. I don't give a damn how my throat hurt. Y'all see me, I done probably ate a whole bag of cough drops. Okay, you're not gonna silence me. Right is right. I see some BS in this. Right is right, and we gotta continue to fight, because I see some foolery. I see some bullshit. Right is right. And who was talking about Levi? They have invested too much money, so they are going to do any. Yeah, yeah, yeah. What the government has done was wasted a lot of funds, American citizens, taxpayers' money on this bullshit, and they don't want to look bad. They don't want another Bill Cosby. I'm telling y'all, and some people still mad because Justice Smollett is out. So it's like Robert gets the shit end of the stick, and they gonna take everything out on him. So they have the big man to come in and damn it, and put his little damn 109 pages. And I'm like, what the hell? Where the hell this come from? Y'all, I'm trying to find it. I know I looked this man up, but any damn who. He was appointed by Joe Biden. So y'all better we ain't finna let them our men become extinct dinosaurs. You understand? Y'all not finna stop our population. We finna get back stronger, and we gonna be more than a 12.1. Okay, and I'm telling y'all, men, we sitting here fighting for y'all. Y'all better keep us strong. Peace, blessings. Sorry, I couldn't continue. Too many pages. I might just do a recording and then just post it so y'all can hear. But I know Miss Tracy. I think she did Bonjean. I'm pretty sure she's gonna do the other two. So we can go over there and watch it, and then we'll just come over here and talk about it later. Okay. Good night, cousin Levi and everybody. Uh, I need to see what you doing over there for old Kales, baby, because I'm telling you right now, I ain't said that you're doing. Cousin Levi. Cousin Levi, I need you to prove to me that you the cousin, honey. Because you working hard to prove that you the cousin. Did Sylvia ever find out if Belief all right? Did she go over there and find out Belief, make sure she was all right? What about that damn what was that damn music thing that Azriel supposed to be doing? How she do Sylvia? Y'all gotta keep us updated. Keep us updated. Y'all till the next time. I said I was gonna do better when I come back, but y'all just please be patient with me until I get myself 100, get myself right, and I'm gonna do my best to come on here and not curse. Make sure I stay on topic, have the content done within an hour. You know, I'm gonna try. So you guys, just all I'm asking y'all to do, just stick with me, be patient with me, cause I'm real. I'm not fake. I'm passionate about this. Um, and they're like family to me now. You know, Lily, all of them, they're like my family, and I just, I'm not fake. What you see here, oh, it's not fake. I have no motives. I'm not on here to gain anything. Only thing I want to do is fight for right, because it's not right. Retaliation, revenge, using a person for their money. This person worked hard for it, and these people are trying to say that women can go in and say any and do everything and bring a man down for no reason. They're just like right now, if I get upset with my man, I can call 911, have some damn tears in my eyes, and the first thing that the officer gonna do is come step outside. I can show him a little scar from them doing lab work almost every other day on me, bruises on my arm from the doctor poking on me and say that he did something to me, and he go to jail. And they don't try to like investigate or look into anything. They will lock them up, no questions, and go and lock these people up. And we gotta change these laws. We have real victims, but some laws need to be changed because I just see a lot of BS, and I don't want my sons going through it. This is a lot. This is a lot. But blessings to y'all. Tell Mr. Kool-Aid I said, hey y'all, I'm out.